Let's talk about discrimination. What will we look at? What is discrimination? What are the state's obligations? What different forms of discrimination are there? What are positive measures and what is accommodation? So first of all, what is discrimination? It is unjustifiable unequal treatment. In German we would say ungerechtfertigte Ungleichbehandlung. That means that there's no legitimate aim to an unequal treatment. So we could also say it's an arbitrary distinction. But this arbitrary distinction has to be based on a ground which is officially prohibited. And it is also discrimination if people only ascribe a certain characteristic to you or perceive you to have that characteristic, even if you don't have it. So, which characteristics could that be? The ICCPR and the ICESCR both enumerate the same characteristics. So you should not be discriminated against race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Non-discrimination and the forbidden grounds are enshrined in all human rights conventions, but they differ according to the prohibited grounds and also the scope of the single clauses, so you have to be careful with that. Also national legislation, what is actually allowed and what is not allowed, which grounds are really prohibited. And we can see that those prohibited grounds are actually developing also with the treaty bodies. And we can see that today age is also a prohibited ground, sexual orientation is a prohibited ground, disability is also prohibited, and chronic illnesses actually count to disability. And I've also seen with the Australian Human Rights Commission that breastfeeding is a prohibited ground there. So you can see that here it states all other status, so it is quite open to what else can be forbidden. However, we need to be aware that not all instances of discrimination are illegal because they are not covered by law. Non-discrimination is even enshrined in the UN Charter, and this is the only human rights obligation that is enshrined there because it says the purposes of the UN are promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. So, what is no discrimination? Unequal treatment, which can be reasonably justified, is no discrimination. And that actually happens all the time, that you treat people's groups unequally. For example, people with children get more social welfare than people without children. And for example, in Germany, we have something like a children budget. Then there is, of course, that you give an old age pension only to elderly people. Also that pregnant women enjoy maternity protection while other groups do not enjoy maternity protection. However, sometimes there may be the question, what is a reasonable justification though? And there's no definitive answer. So take a look at national legislation, what is forbidden, what's not forbidden, and also at case law of courts, of national courts and international courts. And when you are in doubt about if you've been discriminated against, you can always go to court. So let's take a look at the state's obligations. And this is actually derived from the ICCPR Article 26. So the law must protect everyone equally, apart from, of course, justified unequal treatment. And secondly, a state must guarantee equality before courts and in law enforcement, like the police. So state agents must not be allowed to act arbitrarily. Thirdly, a state must also prohibit discrimination from non-state actors, for example, on the job market or when you're looking for a flat. And a state must also act against structural discrimination, so discrimination which is endemic in the system, for example by adopting positive measures. However, it does not have to be positive measures, but the state should do something to tackle systemic discrimination. So as you can see, there is structural discrimination, but there's also direct and indirect discrimination. Let's take a look at direct discrimination first. Direct discrimination occurs when an individual is treated less favorably than another person in a similar situation for a reason related to a prohibited ground. So you would basically have to show that other persons with another characteristic would be treated better in a similar situation. Let's take a look at examples. A doorkeeper at a discotheque denying people entrance due to their alleged ethnic background. I mean, you would have to prove that the storekeeper does it due to the ethnic backgrounds. Sometimes people are so stupid to say, well, it's because of your skin color, and then you have the proof, but otherwise mostly you don't. Another example, job advertisements which only address certain groups like younger people or women only, although other groups could do the job equally well. That's also discrimination. Denying same-sex marriage may also be direct discrimination based on sexual orientation. But here we can see that it also depends on what counts as reasonable justification and what does not. And this example shows an important point, namely that discrimination changes with different times and contexts. Same-sex marriage as discrimination is somewhat acknowledged under international human rights law, but it has been a contentious point for decades. For example, the European Court of Human Rights still gives a huge margin of appreciation to the Council of Europe member states. And it does not necessarily judge that the denial of same-sex marriage is a discrimination. It is indeed the US Supreme Court and also the Inter-American Court of Human Rights which have now taken a stance on equality of same-sex marriage and the other marriage. And what we may see now is a domino effect of acknowledgement, which often happens in international human rights law. So let's switch to indirect discrimination. Indirect discrimination refers to laws, policies, or practices which appear neutral at face value, but have a disproportionate impact on the exercise of covenant rights as distinguished by prohibited grounds of discrimination. So this is a little bit more complicated, so let's take a look at an example. If you require a birth certificate to register your child for school education, but certain groups do not necessarily have a birth certificate, for example, some migrants or some ethnic groups or some indigenous people who simply don't use birth certificate systems. So that's indirect discrimination. Also, if a job advertisement requires fluent German, although fluency is not necessary for the job, it discriminates against migrants. Then there are two good examples from the Australian Human Rights Commission, and it says, it could be indirect sex discrimination if a policy says that managers must work full-time, as this might disadvantage women because they are more likely to work part-time because of family responsibilities. It could also be indirect disability discrimination if the only way to enter a public building is by a set of stairs because people with disabilities who use wheelchairs would be unable to enter the building. This is actually a point. German public buildings always have to be accessible to disabled people. But you can also see that they said it could, because if apparently neutral measures turn out to disproportionately affect certain group members, it does only amount to discrimination when it does not have a legitimate justification. However, there may also be another measure which could reach a legitimate aim just as effectively without disproportionately affecting a group. So we also should take that into account. Okay, so let's recapitalize what has been said on indirect discrimination. So to prove that indirect discrimination is happening or has happened, there must be a policy which an organization is applying equally to everyone or to everyone in a group that includes you. The policy must disadvantage people with your protected characteristic when compared with people without it. You must be able to show that it has disadvantaged you personally or that it will disadvantage you. And the organization cannot show that there's a good reason for applying the policy despite the level of disadvantage to people with your protected characteristic. So this is indirect discrimination, but if the organization can show there's a good reason for its policy, it is not indirect discrimination. And this is what you may have already noticed. Some or many instances of indirect discrimination need disaggregated statistical data to prove that discrimination is happening. This is a problem. Both forms, direct and indirect discrimination, can happen consciously or unconsciously. But even if it is unconscious, unjustifiable, unequal treatment, it is still discrimination, because what is decisive is the actual or possible effect. And of course, if there's a legitimate aim. So for example, if a train company cannot imagine that a woman drives a train, they decide for the male applicant instead. And they may actually feel like that unconsciously, but it's still a direct discrimination. So then there's the systemic discrimination, which can be also called structural or institutional discrimination, and this is a level above direct and indirect discrimination. This discrimination against some groups is pervasive and persistent and deeply entrenched in social behavior and organization, often involving unchallenged or indirect discrimination. Such systemic discrimination can be understood as legal rules, policies, practices, or predominant cultural attitudes in either the public or private sector, which create relative disadvantages for some groups and privileges for other groups. So, and this is what a state also has to tackle, for example, with positive measures. Positive measures are targeted preferences to improve the situation for groups in areas in which these groups are underrepresented or discriminated against due to past or ongoing discrimination. Why past discrimination? For example, if you get rid of an apartheid regime or a slavery regime, a bit of that still stays in the system and in the heads. And this is why positive measures should be adopted also for past discrimination. So to strengthen the equality of treatment, calling it preferential treatment can actually be misleading, because you don't preferentially treat them, but you want to strengthen the equality. Let's take a look at examples of positive measures. You could educate or train especially group members of a certain group. You could implement quotas, for example, for women. And it's also about preferential treatment in job application procedures. And this word, again, is a bit misleading. So, for example, of course, the applicant should be as qualified as the competitors, and that can then be preferred to the other competitors. Not if it's not if the applicant is not as qualified as the other competitors. Okay, we could also call those measures temporary special measures. And this is what the Committee on Economic, Social and Cultural Rights says about it. Such measures are legitimate to the extent that they represent reasonable, objective, and proportional means to redress de facto discrimination, and such measures are discontinued when substantive equality has been sustainably achieved. Such positive measures may exceptionally, however, need to be of a permanent nature, such as interpretation services for linguistic minorities and reasonable accommodation of persons with sensory impairments in accessing healthcare facilities. So apropos accommodation, I will shortly give you an insight into reasonable accommodation, but this is just meant as a side note. And I'm actually unsure to what extent you could go to national or international courts with that. So reasonable accommodation seems to be highly context specific and also country specific. What is reasonable accommodation? It has been written by the Convention on the Rights of Persons with Disabilities. Reasonable accommodation means necessary and appropriate modification and adjustments, not imposing a disproportionate or undue burden, where needed in a particular case, to ensure to persons with disabilities the enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms. So that actually means when an actor does not reasonably take into account the special needs of a certain individual, and if that individual then gets excluded, this may also amount to discrimination. Let's take a look at an example. The employer should try to accommodate the working conditions for the special needs of an employee who had an accident and is now sitting in a wheelchair. So just because your employee is not sitting in a wheelchair, you cannot simply fire him. He should try to adapt to the working environment so that he or she can still work with your company. This accommodation thing also works outside of disabilities. For example, a school should try to accommodate its custodian who is a Seventh-day Adventist. So the custodian cannot work the shifts between Friday evening and Saturday evening, although this would be normal for a custodian to work there. Okay, but of course reasonable accommodation cannot go too far. So the actor only has to try to accommodate as far as it is reasonable and it does not impose huge problems. So when a possible accommodation gives the actor an unacceptable hardship, for example, if it really costs too much money, or if the rights and freedoms of other employees would have to be restricted extensively, then an accommodation is simply not possible and it's no discrimination then. And also the person who has the special need also has to try to find a common solution. Okay, that's it. See you in the session.